please the Lordship. Lordship, if I can be permitted to make a small mention of an item.
Yes.
First, my Lord, an appeal which Lordship had heard a few days back. In fact, Lordship had kept it as CAV. Today, in fact, the appellant was supposed to file their submissions. This is the Electricity Corporation versus Reliance matter, my Lord.
Yes.
Now, what has happened, my Lord, is that on 27th of March, there's been a development. The Supreme Court has passed on judgment, my Lord, which answers all issues in this case. If we can be allowed to place that judgment, my Lord, before this honorable court, we'd be obliged.
Are you mentioning about notice?
Learned AG is there, my Lord. We've informed him.
He's on the other side.
He will go.
The learned additional solicitor general is appearing for the other side.
Yes, my Lord. In fact, he wanted to be present today, but unfortunately, the registry didn't allow mentioning in a CAV matter online. But it's just a
all the sides are present now.
Both sides are present today.
Yes, my Lord.
Then we'll place it for further arguments.
Very well, my Lord.
Yes,
When?
yes, my Lord.
Tomorrow also would be convenient. I would think. Tomorrow, if that is convenient.
But you would be able to do it physically.
My Lord, learned ESG will have to appear online.
All right.
If not tomorrow, my Lord, sometime next week.
Sometime next week, Lord.
Sometime next week, my Lord.
When?
Monday is the holiday, my Lord. Tuesday, Wednesday, whatever is convenient, my Lord.
Wednesday, your Lordship.
All right, please take down. Upon mentioning by, give his name. You are for the respondent.
For the respondent, my Lord.
For the respondent. This appeal is treated as of the day's list. Next, hearing was concluded and judgment reserved. Paragraph. Upon mentioning it is stated that there is a latest pronouncement of the Supreme Court which learned counsel would like to cite. In the appeal, paragraph, in that view of the matter, we direct that the appeal be listed on when 9th April.
9th, my Lord.
Yes, my Lord.
9th April for further argument, comma, after recalling the order quotation hearing concluded stop CAV unquote.
Grateful, my Lord. My Lord, the learned ESG may be permitted to appear online, my Lord.
All right.
Objection.
Mr. Venkataraman, learned senior advocate appearing for the respondent is permitted to appear online.
Grateful.
I will be requesting similar request, my Lord, because there is a matter listed on Tuesday in Supreme Court, limestone matter. So I will also be seeking permission to appear online on that day, my Lord.
All right, Mr. Learned Advocate General and Mr. Venkataramani, appearing for the respondent, are permitted to appear online on the condition that their juniors will be physically present in court.
Yes, madam. Yes, madam.
Right.
Number 1, pronouncement of judgment.
We have held that the appellants have no right to promotion with retrospective effect, and we have affirmed the judgment of the learned trial judge. But nevertheless, in the special facts and circumstances of the case, the appellants are entitled to cost of the legal proceedings incurred by them to pursue their cause of action, whatever faint the cause of action may have been, which certainly arose in 2014. This cost is assessed by us at ₹2 lakhs for each appellant to be paid by the respondents within 8 weeks of publication of this order. This appeal is accordingly dismissed.
Number 2 and 3.
May it please, Lordship.
May I start with an apology in this matter?
Yes.
Kindly accept my apologies, my lord. Your lordships had fixed a date, but my lord, I could not because of certain family circumstances attend.
No, it's all right. It's all dead and buried. Please continue your.
Your lordships are very kind, but my lord, I am personally very embarrassed.
It happens, Mr. Shah. We are not in control of all matters, so it happens sometimes very suddenly. So the court is there to accommodate you.
I am very grateful.
And a counsel like you will never seek something, an unnecessary accommodation. We are aware of that, so there's no
I
problem.
am very, very grateful to your lordships.
Yes, please.
My lord, your lordships were fixed today, my lord, for fixation of further dates. My lord, I don't know when it's convenient for your lordships, my lord. Whenever it is convenient for your lordships, my lord, I'll be happy to come.
Your Lordship, Mr. Deval Banerjee is leading the state in this matter. Subject to your Lordship convenience, Mr. Banerjee is said that if the dates can be fixed from 21st to 23rd of this month, my lord, subject to your Lordship's convenience, 21st to 23rd, because 3 dates were given on last date of hearing for concluding the hearing.
21st is a High Court holiday.
So 22nd, 23rd, 24th, madam.
22nd, 23rd, 24th.
Mr. Shah, is it convenient for you?
Yes, my lord, I will be there. I will be.
Any other fixed matter?
Yes, sir.
What?
22nd, single bench matter and family matter.
Come here. What matters is it? Usual matters or pattern matters? Usual matters. Mr. Shah, how much time will you likely to take?
Well, I will, my lord, finish
In terms of hours?
Well, maybe an hour, my lord. I should be able to conclude in another hour's time because I've made most of my submissions already.
And Mr. AG?
It will take another hour from our side also, and there are other respondents also, my lord, in this matter. So it may spill to at least 2 to 3 hours in total.
All right. list these appeals. Now today, these appeals have been listed for fixation of dates or fixation of hearing dates. Considering the convenience of the court and of learned counsel, list these appeals for further hearing on 22nd, 23rd and 24th April marked at 12:15 p.m. or exhaustion of the regular list, whichever is earlier.
Very good.
Dicta.
Number 4.
Delete them. This is an appeal from the order of learned single judge, my lord. The delay was condoned in the last date, my lord. So, my lord, I pray that we will prepare a paper book, my lord.
This is your appeal.
It's my appeal, my lord.
Where is the order?
My lord. Starts from page 222, my lord.
You have given effect to the order.
No. Yeah. Raj, also praying some interim whatever till the matter is heard, my lord.
Your Lordship, after the order of the single judge was granted in our favor, Your Lordship, we had filed 2 representation for them to accommodate us. Then we are filing the writ appeal instead.
Why representation? You must have asked for compliance of the order.
Compliance, yes, Your Lordship. We had filed compliance. They are saying that we need clarification from the ministry, Your Lordship, because the post has already been filled out. We sent 2 applications, Your Lordship.
This is the wait-listed candidates' right.
My lord. But here what happened, my lord? Certain number of posts were advertised, so we prepared a wait list also. So initially, because she was in the wait list, she was not
Under the
appointed.
rules, the panel was alive or dead at that when the vacancy arose.
My lord, our case was that, my lord, once all the posts have been filled up, my lord, in terms of the law, my lord, the list gets exhausted at the moment all are appointed, my lord.
Under the rules.
My
There
lord,
will be some rules.
The rules is office memorandum, Your Lordship. They had relied on that by rejecting my representation, and even for the single judge also, Your Lordship, that was the rule that we quoted. There was no recruitment rules, there was no service rules as such. There's just the office memorandum of the UPT, Your Lordship. As per that office memorandum, I am supposed to be appointed because the list is valid for 1 year. and the reserve panel was not available by then. What happened here, Your Lordship, was that 2 candidates were selected, both subsequently resigned. I was unaware that they had resigned, Your Lordship, and in the meanwhile they had advertised fresh posts. So I had applied because I had the necessary qualification, Your Lordship. Later on, I came to know.
Our case was, my lord, the moment all the candidates, my lord, appointed from the list for all its purposes, my lord, is
Then why should you keep it alive for 1 year?
now what happened, my lord? Some of the candidates joined and resigned, my lord. And there were certain fresh vacancies, my lord. So what we did,
Then the terms and conditions should have been, after appointment, the panel is exhausted.
my lord.
You have kept the panel alive to take care of these exigencies, like resignation, death, dismissal.
My lord, wait list was only for the purpose if somebody does not join, my lord. If somebody does not join, then wait listed candidate will come, my lord. Here what happened, the selected candidates came and joined already, my lord. And the respondent, my lord, when the vacancy created was re-advertised, he participated in the process, my lord.
Yes, Your
He was
Lordship,
not selected.
because I was not aware that the other 2 selected candidates had resigned, Your Lordship. I was not aware. And office memorandum has clearly stated, Your Lordship, that in the event of death or resignation of the selected candidate, Your Lordship, they are to appoint one the waitlisted candidate.
Wait.
Office memorandum, this is at page number 19, Your Lordship. The second part, Your Lordship.
One line,
No, Your Lordship, the second part, office memorandum, page number 90.
90.
90, yes, Your Lordship.
Where?
Your Lordship, I read the relevant. The Fifth Central Commission in August 17 and 11 of its report has recommended that with a view to reduce delay in filling up the post, vacancy resulting from resignation or death of an incumbent within 1 year of his appointment should be filled immediately by the candidate from the reserve panel, if a fresh panel is not available by then. Such a vacancy should not be treated as a fresh vacancy. This recommendation has been examined in consultation with the UPSC, and it has been decided that in future, where a selection has been made through UPSC, a request for nomination from the reserve list, if any, may be made to the UPSC in the event of occurrence of a vacancy caused by non-joining of the candidate within the stipulated time allowed for joining the post, or where a candidate joins but he resigns or dies within a period of 1 year from the date of his joining if a fresh panel is not available by then. Such a vacancy should not be treated as fresh vacancy. Similarly, Your Lordship, it has been at page 91, it has also stated that it has also been decided that where selection for posts under the central government are made through other recruiting agencies such as Staff Selection Commission or by the ministry/departments directly, and the reserve panel are similarly prepared, a procedure for operation of reserve panels maintained by UPSC as prescribed and followed through above will also be applicable for the reserve panels maintained by other recruiting agencies/authorities. Your Lordship, here, they themselves quoted this office memorandum. And Your Lordship, prior to us filing the writ petition,
Appointment has been made after advertisement.
My lord, even before the order was passed, my lord, pursuant to second advertisement, my lord, where she also participated,
Appointment made.
appointments have been made. But that is causing.
but they have not.
Any vacant posts are there.
The vacant posts at present are not available. That is the reason, my lord, we have filed this appeal.
Your Lordship, there was a stay, interim stay in my favor, Your Lordship. That has not been complied with by the appellants. Prior to our filing the writ petition, Your Lordship, they had sought a clarification from the ministry, Your Lordship.
What happened, my lord, only one thing that can be done is, because there is one post is there which is a promotional post, my lord, from the lower grade. So if Lordship directs us or give us that liberty, my lord, to fill up that vacancy, and the next post when it arises, we'll fill that by promotion, my lord, at that point of time. My lord. That is only way out, my lord, at this juncture, my lord.
Promotional post for which post?
Same grade, my lord. Some posts are reserved for promotion, my lord, which are lying vacant as of now. We have not held the DPC.
And this is direct recruitment.
This is direct recruitment. My lord.
Same post.
Same post, my lord.
But then those who are aspirants for promotion will be affected.
Only for few months, my lord. Because we are, by ourselves, we are not able to do that. Well, Lordship directs or give us some leeway there, my lord. We can accommodate.
A supernumerary post.
Supernumerary, my lord, is require a very lengthy process, my lord. That is.
Why? Because by taking away a promotional post, you will be doing damage to those persons.
Although, otherwise, the only alternative is to the last candidate who has been appointed, we have to remove him from service, my lord, and then appoint him.
When he was appointed?
He was appointed in 24 months.
So these are doctors.
No, my lord, these are LDCs, my lord. Lower division clerks. Well, Lordship gives me 1 week's time, my lord. I'll have instruction on what can be, how to sort it out.
When is the next vacancy to arise in this LDC post?
So the vacancies will next arrive only when there some promotions are made from this grade to the next grade, my lord. All sanction posts have been filled up now, my lord. Lordships can give me a week or 10 days time, my lord. I'll call them how to sort, how it can be sorted out best, my lord.
No, some pressure has to be exerted. We will say they will not take any proceedings in contempt. We will hear out the appeal,
My lord.
provided you create 2 supernumerary posts within 4 weeks from date and don't fill them up.
My lord, instead of that, my lord, Lordship only give me just 3 or 4 days time also, my lord. I'll ask them how to sort it out.
They will sort it out at the expense of others, that we will fill a promotional post, etc.
Or we'll have to remove
There
one
is no
person.
problem in supernumerary posts. As and when the posts become regularly vacant, supernumerary posts will be abolished and they will be absorbed in the regular thing. That's all.
I'll kindly give 3 days time, my lord. If the matter comes on Tuesday, my lord, I'll have proper instructions on the matter.
All right. This appeal from a judgment and order dated 6 September 2024 of a learned single judge of this court. In the exercise of his writ jurisdiction, comma, allowing the same by directing the appellants to accommodate the respondent in the post of LDC with retrospective effect, comma, is formally admitted. Learned Deputy Solicitor General appearing for the appellants. Praise for stay of operation of this order. On a prima facie paragraph, on a prima facie appraisal of the facts of this case, we find that the respondents were in the panel of successful candidates. Was waitlisted. By the Office Memorandum dated 13 June 2000 of the Department of Personnel and Training under the Ministry of Personnel, Public Grievances and Pensions, Government of India, no, before that you read the panel was valid for 1 year. Then so and so dated so and so. Upon resignation or death of an incumbent, within 1 year, any vacancy is to be filled up. From the existing panel without taking recourse to a fresh recruitment or selection process. In the instant case, 2 selected candidates resigned. Full stop. The respondents became entitled to be appointed from the said waiting list. Instead, the appellants re-advertised the vacant posts and the comma invited applications, comma conducted the recruitment process, recruitment stroke selection process, and have filled up all the posts. Prima facie, we are of the view that the respondents were entitled to be appointed from the existing panel, of waitlisted candidates. Paragraph. Learned Deputy Solicitor General seeks time to take instructions in the matter. We grant such opportunity to him to come up with a concrete proposal before the court, including creation of 2 supernumerary posts,
Only one, my lord. Only one person is come before the court, my lord.
not 2.
Number two, second candidate is come, my lord.
Okay. They make it respondent everywhere. 1 supernumerary post to accommodate the respondent.
Yes.
To be later abolished upon creation of a vacancy in the subject post. With supernumerary post to be abolished and the incumbent absorbed into the regular post as and when the vacancy arises. List this appeal for further consideration. When, Mr. Deputy?
My lord, 7th, 8th, 9th, any of this?
7th is a holiday.
8th or 9th, my lord.
Holiday on 8th April.
Hello, my judge.
Number 5.
May it please your lordship.
Yes.
My lord, the question which arises before your lordship, my lord, whether right, title and interest can be decided in writ proceeding when the appeal lies before, my lord, deputy commissioner. My lord, the case in hand before your lordship is, my lord, that in 2001, my lord, one arbitration award was passed, that your lordship will find at page 40, my lord, 40.
My Lord, before my learned friend continues, I'm slightly handicapped today because I don't have the copy of the writ appeal, my lord. I'm yet to receive from my clients, my lord. So if your lordships can accommodate me
Case
for...
already completed, my lord. We have filed affidavit also.
Yes, my lord, but I have not received as counsel, my lord. I'm yet to receive the copy.
By this arbitration award, my lord, property situated at Shillong, it was awarded to my husband, your lordship. This award was challenged before, because there are so many property, including in Guwahati, before, my lord, learned district and session judge Guwahati, that your lordship will find at page 45.
Yes.
And by the father of respondent, number 1, 2 and 3, and learned district and session judge, my lord, dismissed their miscellaneous case under section 34. And against this order, my lord, no appeal or application was filed. Meaning thereby, my lord, this award, it attains finality, my lord. And accordingly, my lord, still today, my lord, I am in possession of property situated at Shillong. What has happened, your lordship? After this award, my lord, it was passed way back in 2008, this order. Nothing was done, my lord. All of a sudden, when my husband was ill, your lordship, they approached respondent number 4, and in connivance with respondent number 4, they mutated the Shillong property in their name. Against that, I lodged an FIR and objection before respondent number 4. The FIR was transferred to CID and investigation is still going on. After receiving my objection, my lord, respondent number 4 passed an order that your lordship will find at page 189, saying everything, my lord, concealment by respondent 1, 2 and 3. Page 189, my lord. May I read, Your Lordship?
This is an appeal or a writ petition.
They filed writ petition challenging this order before learning signal judge. Last three occasions, respondent number 4 has taken time for filing affidavit. One day, out of his out of blue, learned counsel appearing for the respondent number 4 submitted that matter may be remanded back. No opportunity, nothing has been given to us, my lord. And my right, title, everything was set aside by learned single judge, Your Lordship, by simple order, only on the basis of version of respondent number 4. My humble,
Who was the order?
page 197, Your Lordship. In fact, appeal is, writ petition is not maintainable at all, my lord. 197, relevant, 198, Your Lordship, you can see, the instant writ petition is directed against the impending order declaring so-and-so issued by the as null and void. That order that I have shown, my lord. Series so-and-so, then counsel appearing for the petitioner at the time when the new impugn patta so-and-so was issued with in question. The petitioner who belonged to the same joint family were not heard. They please that I will show, my lord. They appeared, they submitted their objection, everything. Series so-and-so, counsel appearing for respondent number 1, here respondent number 4, has submitted on instruction. No instruction, written instruction was given. That as the petitioner were not heard, the respondent 1 is agreeable to allow them to file their written statement or objection and the matter be heard at face. Considering the submissions of learned counsel for the respondent number 1. This matter is disposed of at this stage itself by setting aside the order so-and-so, so-and-so. My lord, I have not been heard, my lord. The submission, oral submission, whereas on the last 3 occasions, time was taken by respondent number 4 for filing affidavit. But in that day, all of a sudden, and whereas, my lord, opportunity was given to them, your lordship, may kindly see, notice was issued to respondent number 182. They appeared before the, my lord, respondent number 4. They filed objection, everything has been done. In fact, once FIR, in the FIR, it has come to the light that in connivance with respondent number 4, respondent number 1, 2, 3, they manipulated the records, suppressing the arbitration award and all, and mutated the property in their name. When they came to know, respondent number 4, they passed this face order. In the order, your lordship will see, they have admitted that they have committed mistake, 189. Mistake was committed by them. They have not seen this arbitration award and order passed by learned court was suppressed by respondent number 1, 2, and 3, and accordingly that Shillong property was mutated in my name. Even assuming they are agreed by this order, my lord, appeal lies before, as per my lord, land regulation. This is adopted by this state of Meghalaya, my lord. Appeal lies before deputy commissioner, my lord. Because facts are, disputed facts are there, evidences are required to be adduced. How read court can go and decide, my lord? Well, this is the and this is adopted. My lord, I have given strong, my lord, objection against respondent number 4, against whom FIR is there, your lordship. Second page, my lord, may kindly see 147. I'm giving. We'll give. Oh. Take a copy. I'm giving. This. Regulation 147, second page, my lord. Authority to whom appeal lies to the deputy commissioners, close B, my lord. Appeal shall lie under
Were respondent number in the writ?
in the respondent number 2, my lord. My lord, this is a case, either your lordship may remand it back, my lord, or your lordship may hear it.
You are Amit Saraf, Samit
My
Saraf.
lord, they are petitioner in the writ petition. They are my cousin, my nephew, your lordship. There is a fight between uncle and nephew. nephew has taken everything by way of arbitration. He has disposed of his property after taking in arbitration. Now, whatever the property I got, he has eyes on my properties. I am residing in Shillong since 1948, my lord. And Shillong property was given to me. Still, I am in possession of that property.
You are respondent number 2.
In writ petition.
You were not given notice.
Notice was given. But in that day, my lord, learned senior counsel Mr. Mojika was appearing. The moment he is, learned counsel has conceded before the court, and learned court has passed.
Your Lordship, the appellate.
Considered that the matter may be remanded back to the respondent number 4.
Who considered?
Respondent number 4 counsel, my lord. It is reflected in the order.
They are also served.
No, my lord. This is the CM of him. CM, my lord, who has issued patta. Authority, my lord.
He is not a party.
Party, my lord.
Number?
Here in writ appeal, respondent number 4. My learned friend is appearing for respondent number 4.
Your Lordship, it is incorrect to say that.
And my lord,
has not
let me conclude.
You were present in before the learned single judge.
I have seen video clipping, your lordship. And nowadays everything is online, my lord. That I have seen. How the counsel, my lord, your lordship will see the previous order. They are seeking time for filing affidavit. Last 3 orders, I will annexed. But why? What was the reason that in that day it was considered? And one FIR because of their connivance is pending.
They are for which respondents?
My lord, they are appearing for respondent number 1 who has issued this order. Page 189.
Silent Hima.
Yes, my lord. This is Shyam Hima, William and Darbar. Respondent 4. By this order, my lord, my rights. And my lord, the order passed by respondent number 4, page 189. They admitted that they had committed.
Where is the cost title to us?
First title, my lord. In the writ petition.
Yes.
My lord. I have annexed, my lord. My lord, page 67. Page 67, my lord. And here page 70, my lord. Respondent number 1, 2, and 3, they are petitioner. Respondent 1, respondent number 4, and respondent 2, my lord, appellant before your lordship. I have categorically stated, my lord, connivance of respondent number 4. And my lord,
You are 2, Samit.
I am 2. Sushila Devi Saraf. My husband died, my lord.
You are Suchila Devi Saraf,
Sushila Devi Saraf.
not Samit.
No, my lord. I am Sushila Devi Saraf. I am wife of Kailash Saraf. By way of arbitration award, that property was allotted to Kailash Saraf. My husband died in the year 2023. Page 195, 196, time taken by them, your lordship, it is reflected. They are going to file. I was under the impression they are going to take time for filing affidavit. But in that day, my lord, what has happened that I don't know. The best known to them. All of a sudden they came and verbally submitted before the court. Conceded before the court. And FIR, my lord, will see against that page 37. Same thing they have done earlier. So matter is now investigated by CID.
So only the respondent number 1 appeared.
One appeared. My senior counsel Mojika, he was supposed to appear, but by that time he reached, my matter was over. Everything. I was seeing in that video your option.
Respondent number 1 is supporting them.
Supporting them.
The order is passed by the respondent number 1.
My lord, FIR against respondent number 1, page 37. They are supporting them. And we have filed FIR against them.
But you were served.
Sir, I was appearing, but last two or three occasions, they had taken time since the writ petition was against their order that they will file affidavit. That is reflected from page 195 and 196. Order passed by this honorable court. But they have, all of a sudden, they came and said that I am conceding.
So why did you appear?
In that day, you are asking. No, in that day, I could not, because the moment Mr. Mojika appeared, my lord, it was over. So I have no option but to file appeal.
So how can you say this? The moment he...
Now the video recording is there, your lordship.
It was the junior of the senior counsel.
Yes.
Was
He called me thereafter. He couldn't appear because he conceded. In fact, page 195 and 96.
It is reflected in the order also, Your
Let me
Lordship.
conclude, London Council. 195, my lord, can you see, he has taken time for filing affidavit in opposition. What was happening that day, all of a sudden, orally, without any written instruction, he conceded before the court. Page 195 and 196, my lord, can you see, time was taken by them. Since they are the main respondent, so I was under the impression after filing of their affidavit, we will file our affidavit. Page 195, my lord, can you see? Series so-and-so has entered appearance today on behalf of respondent number 1, so-and-so respondent number 2. They pay for and are allowed 2 weeks time to obtain instruction and file affidavit. Next, my lord, 196. This so-and-so, pay for and are allowed further 2 weeks time to file their respective affidavit. Page 195 and 196. Why affidavit was not filed and orally conceded before the court, I fail to understand, my lord. Already one FIR is, they are facing criminal investigation. On 20, this order was passed. On 5th. In fact, my lord, page 37, if your lordship will see FIR lodged by my husband, at that time he was alive. Clear-cut case of misuse of your official position, my lord. And police is now going to file, my lord, charge sheet against respondent number 4 and respondent 1, 2 and 3. Page 37, my lord. That's why I have made party to state of Meghalaya. Page 37, my lord. 37.
Two options are there. Either we send it back to the trial court to hear them and pass an order by setting aside this order. Or we will hear out the appeal, we will hear it out ourselves, but order will be stayed.
Your Lordship, if I just make a submission.
Yes.
Your Lordship, the two grounds of appeal for the appellant is that the learned single judge did not hear them. That's number one. But it is a fact that's recorded in the order dated 5/12/2024 that the appellant, the respondent number 2 in the writ appeal was present, was represented by the counsel. That is number one. During that point of time, no objection was raised when I had made a submission that this matter be remanded back to the respondent number 4 to hear the matter fresh and to pass necessary order. The Lordship, what happened in this case is that the husband of the appellant has objected to the pata that was issued in the name of the respondent number 1, 2 and 3. He applied for a fresh pata to be made in his name. During the course of the proceeding, Your Lordship, the husband of the appellant passed away. During that time, the appellant filed a petition before respondent number 4, and based on that petition, on that letter, the respondent number 4 passed the impugned order, which was challenged during the petition. no opportunity was given to the respondent number 1, 2, and 3. Based on that, Your Lordship, after seeing the report, I had made a submission before the learned single judge that let this matter be heard afresh after taking the written submission of both the parties, then only a fresh order will be passed. Based on that, the learned single judge has passed this order, Your Lordship.
Page 182, my lord, can you see opportunity was given or not?
I think it is my time to, you have already made your submission.
You see, this is not even a proper forum for this matter. It is a civil dispute.
Yes, Your Lordship. That is why, Your Lordship, the writ petitioner, the respondent 1, 2, and 3, came before the learned single judge with one prayer. The prayer is that they were not given an opportunity, they were not heard when the interim order was passed. On that basis, after going through the records, it seemed that there were lapses on our part, not hearing both the parties before passing the order. That's why I made the submission before the learned single judge. And based on this order, Your Lordship, we have already issued notice to both the parties to appear before the office of the respondent number 4.
All right.
(182) notice, my lord. He was aware, he appeared before the respondent number 4 and bail petition, because bail was taken by them, in the bail order, everything is reflected, that they appeared, they file objection and all. How they can say they are not aware? Even if that is the case, appeal lies before Deputy Commissioner. Reed Court is not going to decide.
Yes, this is not a revenue. This is a tribal land, Your Lordship. So this regulation that the council has
also.
It is not applicable to the tribal land, Your Lordship.
In that case, suit may be filed, but not Reed Court.
You see, Reed Court has entertained them. Now it is very unjust at the appeal stage to again send them back to ground zero.
Your Lordship may hear in that case, my lord. I am ready to place.
But let the learned trial judge hear it out upon hearing you.
My lord, that is what.
This appeal from a judgment and order of a learned single judge dated 5th December 2024 in the exercise of his writ jurisdiction. Setting aside the mutation dated 11th March 2024 issued by
Respondent number 4.
respondent number 4. Follow is formally admitted. Then, as the respondents are represented by learned counsel, we dispense with all formalities and expedite. This is the appeal. A formal paperwork, informal. Informal paperwork by 24th April. This is 8th May. 8th May. Certain important issues are involved in this appeal. As follows, colon. whether the alternative remedy of appeal provided in the statute. Where is it,
Regulation or suit, my lord, they can file suit also.
where is it provided?
In the Meghalaya Land Revenue Regulation,
Take up. There, para 11.
my, 140, regulation number 147. Or they are saying if it is not applicable in that case, suit is maintainable, my lord.
Next, by the disputed questions of fact involving legal rights over a patta can be decided by this court. Therefore, in the meantime, the improved order dated 5th December 2024 will remain stayed. However, the parties will maintain status quo over the patta. You given a date of hearing of the appeal.
Number 6.
Deep knowledge.
You have not segregated any matter, as I told you yesterday. Have you segregated or not? What? I told you to segregate, huh? Where? Where is tomorrow's list? Huh? But you have segregated.
Please, Lordship. In view of the order dated 24 February 2025 and 12 March 2025, I have taken a step and served a notice to the private respondent. However, still awaiting. I have even approached the post office for regarding the status of the case. They have not replied. So the service report is still awaiting, my lord. So
But this is the, how many times adjournment you are taking?
so we have sent it to the post. Now they have not replied with that service has been delivered to the private respondent or not. Once it's delivered, we will file the affidavit of service. Of course, there is order. We are supposed to file the service report, but then we have not received any communication from the senior postmasters. We have even written a letter, and then usually
can
they
it be?
reply.
For months, no communication.
No, they have not given. We have sent a letter recently, this one, on 19, this one, but then they have not replied. We have sent on 19 March 2025.
Advocate on record for the appellant is unable to produce any evidence of service. The matter is pending for a very long time. As a last chance, we make this application returnable on failing which we shall be compelled to issue a re-service order. Item number 1262. Six two.
Item number 7 to 21.
Mr. Lordship.
You show me that segregated list. You put all the matters today. You show me that list. I want to see. What use that? Show me the list. What use that? Yes.
Item 7 to 21 is against the common judgment and order of learned single judge, my lord. But today, the application for condonation of delay is listed in all these matters, my lord. There is in the lead matter, my lord, which was filed before vacation, there is a delay of 111 days, my lord, in the lead matter. But in other matters, my lord, there are delays from 129 to 182 days, which were filed after vacation, my lord. In lead matter, the order and judgment of learned single judge is of 11th July 2024, my lord. And in the lead matter, the writ appeal was filed on 29/11/2024, my lord. So there is a delay in effect of 111 days, my lord. That was because of number of reasons, my lord. My learned friend has filed objection to the condoning of delay, my lord, but the issue involves 314 petitioners, my lord, who are working in the work charge establishment, and the learned single judge has directed that they will also be entitled to pay in terms of recommendation of pay commission, my lord. In my humble submission, that the recommendation of pay commission was not for the work charge employees of work charge establishment. It was only for regular employees, my lord. So therefore, the issue requires some consideration by this honorable court, my lord. And delay we have explained by showing that there was puja vacation and some vacation. Therefore, there was some delay in filing the appeal, my lord, of 111 days, my lord. And lordship may consider condoning the delay and hearing the matter. My friend
Take
has
cost,
also...
we will condone the delay.
My lord.
Take cost in each appeal, we will condone the delay.
My lord, ordinarily we would not object to delay, my lord, a delay of 111 days. But there is a problem here in the petition filed by the applicant seeking condonation of delay. My lord, there is no explanation, my lord. No reasons have been set forth in the petition as to what prevented them from coming to the court within the time prescribed under limitation, my lord. Unless the reasons are
What is the order you are enjoying?
my lord.
What is the order, impugned order you are enjoying?
My lord, the order they have the order impugned. My lord, what has happened here in the main matter, my lord? My lord, the crux of the issue in the main matter was whether an official notification can override a statutory provision. Now, my lord, when the government of Meghalaya accepted the recommendation of the 5th Pay Commission, my lord, and then a statutory rule was framed in exercise of powers under Article 309 of the Constitution of India. Now, my lord, these rules provided that the benefits of the fifth pay commission will be applicable to all the work charge employees. Now, my lord, what has happened is that insofar as the implementation of these recommendations have been is concerned, my lord, they have not fully applied it to all work charge employees. There are some work charge employees who are still getting the benefits of the fifth pay commission, whereas some of the work charge employees are not did not get the benefits. They approached this honorable court by filing several writ petitions, my lord. I was the petitioner in the writ in the lead writ petition. Now, my lord, what happened was that after the rules were framed, the Meghalaya Pay Revision Rules 2018 were framed. These rules at rule number 2 contained a stipulation which says that the benefits of the fifth pay revision will be applicable to all employees in the government of Meghalaya, including employees in the work charge establishments. It makes no differentiation between work charge employees and based on the date of their appointment. Now, what happened, my lord? They came up with a notification, the respondent came up with a notification saying that the benefits of the fifth pay commission will be given only to those work charge employees who were appointed post 1/12/1997. Prior to 1/12/1997. So, my lord, we contested this notification and contended before the learned single judge that the law does not, if at all they want to bring such kind of a thing, they have to amend the rules.
Yes.
Now, our contention was plain and simple, my lord, that statutory notification do not have the power to override, government notification do not have the power to override statutory rules, my lord. And accordingly, the matter was decided.
Lordship, I will satisfy this court. I will satisfy this court. May admit the matter for hearing, my lord. I will satisfy that the work charge employees are not at par with the regular employees. The recommendations are not applicable to work charge establishment employees. And
He wants to argue the Section 5 matter. Let him argue.
Yes.
Yes, please.
We can't stop him.
My lord, I would not have, my lord, I'll fairly submit, I would not have raised any objection, but however, my lord,
This is neither here nor there. I would not have opposed adjournment, but I am opposing adjournment. This is neither not a here nor there. Either you.
my lord, it is, my lord, of course, I filed my objection to it. My lord,
Where is the order? Page?
it's not an
Case, your lordship, 27. And the relevant starts from 69, my lord.
Where is that list?
The order impugned is in the,
Where is that notification I told you that this list will be divided between Thursday and Friday? Have you published it? No. You will be show cause today. I am very sorry to say that you have the audacity to disobey the Chief Justice. I am very sorry. Too much of courage and some other considerations perhaps in preparation of the list. You come and sit in my chamber. Yes?
my lord, the order impugned is dated 11/7/2024. Ordinarily, the writ appeal ought to have been preferred within 30 days, that is on or before 10/8/2024. It was not. So it was not prepared within the time prescribed under limitation. It was filed sometimes in the month of November.
29th November. It was filed on 29th. 29th November.
29th November it was filed. It was moved on the 3rd of December. My lord, in the application, my lord, at para 5, at para 4 and 5, my lord, they have made an attempt to say to explain the delay, but in my humble submission, my lord, this explanation is not sufficient, my lord. In para 4, it's stated that it is respectfully submitted that in view of the directions passed by so and so by way of the impugned order dated so and so, the petitioner sought legal opinion from the law department. After obtaining opinion in the aforesaid matter, a decision was taken to file an appeal against the impugned order dated so and so. The petitioner further submitted, however, in the meantime, Honorable Court, High Court was closed for Durga Puja holidays and Diwali holiday. Immediately thereafter, the appellants took the requisite steps. Now, my lord, in the last calendar year, the the court was closed for puja holidays from the 5th of October to the 12th of October. My lord, October 14 to October 18 was working days. Thereafter came Saturday, Sunday. Then October 21st to October 25th were working days. October 28th to October 30 was working days. Now Diwali holiday was only on the 30th. Now my lord, there is no explanation as to why it could not be filed within these days when the court were open. The only explanation that they have tried to come up with is that at para 5 that the Honorable Court was closed for puja holidays and Diwali holiday. Thereafter, there was 3, 4, 5 working weeks, my lord.
What are these impugned orders? 23/3/2020 and 5/7/2022?
These are notifications you challenged. I'll just have to go back. A little bit appeal, no? My lord, impugned order dated
Page 87.
page 87. This was not impugned. My lord, this 23/3/2020 is the notification by which the respondents have held that the benefits of the Fifth Pay Commission will not be applicable to work charge employees who are appointed post December 1997.
And 5/7/22?
5/7/2022. I'll just page 125 onwards. 125. 23rd March. And then Third March 2020 and 5/7/2020. 249. My lord, 249. Now, my lord, my lord, 249 is a letter which says that the implementation, it is also on the same subject, that the recommendation of the Fifth Pay Commission cannot be applied to work charge employees who were appointed after 27/10/1997. These are similar notifications.
Give us a date, Mr. AG, when you can contest the section 5 application.
Your Lordship may have it after 24th, my lord. 25th, 25th, your Lordship may have it, or whatever convenient to your Lordship.
Just point out the rules. Just point out the rules.
24 those matters are fixed, I think.
Yeah, 20 till 24th, the your Lordships are occupied. After 25th.
Distillery matters.
Yes, my lord. Distillery up to 24th, your Lordship list is full, my lord.
28th.
Yes, my lord. 28th.
Okay. All right.
This section 5 application is contested. Set down the same for hearing on 2/8 April. Similar order in each matter.
Yep.
Item number 22.
Obliged, my lord.
Obliged.
May I please, Your Lordship?
Yes.
Your Lordship, here I am appearing on behalf of respondent number 2, LSC, Your Lordship. Your Lordship, I filed a miscase seeking permission from this Honorable Court to file reply to the writ appeal along with certain documents, Your Lordship.
Under which provision?
Your Lordship, I have not filed under any provision, Your Lordship.
It can only be under Order 41, Rule 27, CPC.
Your Lordship, then I may be allowed to correct the
That is appearing in the list.
Yes, Your Lordship. Miscase 42 of 2025.
What is all this?
Your Lordship.
Reply with necessary documents.
Yes, Your
You
Lordship.
have not even specified the documents.
Your Lordship, the joining, there are a few documents, Your Lordship. The joining,
Dismiss.
Your Lordship, can we,
There are no particulars, nothing. Please take down. This application is devoid of any particulars. Or description of any documents which the appellant wishes to introduce in the appeal. Full stop. This application is accordingly dismissed with leave to take out a proper application if such right exists. Such right is enjoyed by the appellant. What application you have drafted? Necessary papers?
Your Lordship,
Give the details.
Yes.
Why you want to introduce? Why you were not there at the trial stage?
Your Lordship, at the,
Read Order 41, Rule 27, Civil Procedure Code.
yes, Lordship.
Yes.
23.
Okay, Your Lordship.
Obliged. May it please your lordships. Your lordship, the conducting counsel, Mr. Sen, is on like your lordship. So your lordship, may the matter
Conducting
be
for who? Appellant or respondent?
I'm
with the respondent, your lordship.
Appellant.
for the respondent, Lordship, yes.
The first adjournment or many times adjournment is being taken?
Lordship,
The first adjournment or many times adjournment is being taken?
First adjournment, your lordship.
Yes, no further adjournment will be granted.
Is on like your lordship.
This order was passed.
since my friend is on left, Your Lordship, I would not. What is?
No, what is this matter about?
This is a promotion, Your Lordship. It's a wrong promotion, Your Lordship. We have a recall that promotion, Your Lordship. So against that, Your Lordship, a writ petition has been filed, and the order of reverting the writ petitioner respondent, Your Lordship, has been quashed by the learned single judge. So we are agreed by that, Your Lordship. We are before Your Lordship.
Promotion order has been quashed.
No, Your Lordship, the order of reversal of promotion has been quashed, Your Lordship. That means the promotion which had been given earlier stand.
Appeal is ready for hearing.
It's a Lordship, yes. It's we have filed the paper book also, Your Lordship.
Your lordship, if I may just call the conducting counsel, your lordship.
Then, Lordship, Lordship is pleased to take up the matter also on 9, Your Lordship, since he's not here. My friend, Mr. Sen, is not here. That happened 9, Your Lordship. If he's
he will ask for his adjournment. I don't know the practice of here of seeking adjournment for the other side.
No, Your Lordship, it's not.
You start your latest appeal. Here he has come.
Yes, Your Lordship, yes.
Well, here is a normal thing that
Your Lordship,
I'm being up for the adversary.
I'm not asking for adjournment since she has made that submission, Your Lordship.
I'm sorry, my lord, I'm a little late, Your Lordship. I'm sorry. Because there are a lot of quality matters in this court, but singular lack of eagerness on the part of learned counsel to proceed with the matter. Only adjournment.
Lordship, I'm not seeking for adjournment since she has made a submission. Then,
At least start the matter.
Lordship, yes, I'll
Give
start.
the review.
Lordship, yes. May it please Your Lordship. Lordship, this is an appeal, Your Lordship, against the judgment passed by the learned single judge, Your Lordship. Lordship, that judgment is at page 80. Page 80, Your Lordship. The judgment starts at page 81. Lordship, before I come to the impeached judgment, Your Lordship, if I may submit the facts, Your Lordship.
Please do. Yes.
Lordship, the writ petitioner here, the writ petitioner respondent here in Your Lordship, she was appointed in the year 1989, Your Lordship, as a typist. Lordship will find it at page 24. Page 24, Your Lordship, serial number 3. So for a post to be upgraded to a next higher post, Your Lordship, there is a requirement under the rules, Your Lordship, that one should pass the typing test, Your Lordship, to be conducted by the Meghalaya State Service Commission, Your Lordship. So in the year 2016, Your Lordship, the authorities informed the writ petitioner as to whether she would like to appear in that test. Lordship, I look up to page 28. Lordship, this is the letter issued by the PWD department to the respondent writ petitioner, Lordship, to appear in the speed test for typist grade 2. Then, Lordship, she accepted this, Your Lordship. That the letter of acceptance, Your Lordship, will find it at page 33. Lordship, page 33, she accepted, Your Lordship. As I have submitted, Your Lordship, as
Yes.
Lordship, she accepted, Your Lordship, but she did not pass, Your Lordship, in the speed test conducted by the Public Service Commission, Your Lordship. Lordship, this is the as per requirement of the Rule 2010, Your Lordship, which Your Lordship will find at page 31. Lordship, kindly come to page 31. This is the Meghalaya Directorate's Establishment Ministerial Service Rule 2010, Your Lordship. Lordship, kindly come to 2, Your Lordship.
Sorry?
Lordship, kindly come at page 31.
Yes.
Lordship, kindly come to page Rule 222, Your Lordship. Type is grade 2.
Eleven two.
No, Your Lordship. Lordship, yes, 11.2, Your Lordship.
Yes.
Lordship, kindly see 2 bracket 2, typist grade 2. Typists with minimum 3 years of qualifying service in grade 3 shall be eligible for appearing the speed test of 45 words per minute to be conducted by the Meghalaya Public Service Commission, and their placement in the grade shall be subject to passing the speed test. So, Lordship, in order to be accredited to a grade 2 post, Lordship, a grade 3 employee has to come out successfully of 45 words test, Lordship, to be conducted by the Public Service Commission.
She has qualified in this test.
No, she failed, Your Lordship. She failed.
Then,
Your Lordship, in the year 2020, Your Lordship, what happened, Your Lordship? A DPC was held, Your Lordship. Lordship will kindly come to page 35. Lordship, kindly come to page 36, agenda number 5. Lordship, by this department, DPC, Lordship, was held in the year 2020. The red picture respondent was promoted, Your Lordship, without ignoring that fact, Your Lordship, that she failed in the speed test, Your Lordship. And there is also an office memorandum, Your Lordship, which keep the option, Your Lordship. We keep the option. Lordship, that Your Lordship will find it at page.
but then what is the writ about? She was promoted.
She was promoted, Your Lordship.
Then,
she was promoted, Your Lordship, but in the year 2021, Your Lordship, she has been reverted back, Your Lordship, to the original post, Your Lordship.
why?
Lordship, because that promotion has been made, Your Lordship, without considering the requirement of the rule and also the office memorandum, Your Lordship.
Which year she was reverted?
Lordship, she was in the year 2020, Your Lordship.
So promoted in 2020
Lordship, yes.
and reverted in
21.
She was reverted in the year 21, Your Lordship.
within 1 year.
Lordship, yes.
You can continue tomorrow.
Lordship, yes.
Hearing commences. Full stop. Mr. Nombo, learned advocate for the appellant, commences arguments, but does not complete the same. List is appealed for further arguments tomorrow.
Tomorrow.
Right.
Obliged, ma'am.